A federal judge looked her straight in the eye and said, "You're not qualified to be here." The courtroom laughed. Reporters whispered. But what happened next left everyone speechless. This isn't just a legal drama. It's a true story of a young woman who turned humiliation into a historic victory. Stay with us, because you're about to witness Karoline Leavitt do the impossible. You're not qualified to be here. The words echoed through the courtroom like a thunderclap. All eyes turned to the young woman standing at the center of it all, Karoline Leavitt. She didn't flinch. She didn't drop her gaze. She simply stood tall, calm, composed, and focused. In that moment, the tone of the entire courtroom shifted. Earlier that morning, the courthouse was filled with quiet tension. Reporters had set up outside. Security was tight. Legal observers murmured about the constitutional case scheduled for hearing, a case that had sparked national interest. But there was another reason the courtroom was packed. Karoline Leavitt, known as a sharp-tongued political figure, was about to stand before a federal judge, not as a lawyer, but as the person delivering the argument herself. She wasn't admitted to the bar. She wasn't a practicing attorney. She was, by all definitions, unqualified in the legal sense. Yet here she was. What brought her to this point? Just 2 days earlier, the legal team defending a high-profile constitutional case fell apart. The lead attorney dropped out, citing a conflict of interest. The second-in-command was hospitalized. There was no time left. Panic set in. The team had no one to appear in court. The opposing counsel, an elite, government-backed legal team, was prepared to dominate. That's when Karoline stepped up. "I'll do it," she said. The room had gone quiet when she made the offer. She wasn't joking. Though she had no formal legal experience, Karoline had spent years immersed in constitutional studies. She had worked in political strategy, advised campaigns, and written policy briefs. She knew the Constitution inside and out. And now, she was offering to do what no one else could or would: argue the case in court. Some in the room resisted. It was risky, unheard of, but there were no alternatives. The case couldn't be rescheduled. With no lawyer, it would be dismissed, and with it, a major fight for constitutional rights. So they gave her the file. She studied it through the night. She reviewed case law, memorized precedents, prepared rebuttals. By morning, she walked into court, not as a legal expert, but as a determined citizen. The courtroom was tense. Every seat filled. The press lined the back wall. The opposing legal team smirked. They came armed with documents, paralegals, years of courtroom experience. Karoline had a binder, a notepad, and a highlighted copy of the Constitution. Then the judge entered. The courtroom rose. He was known for his strict courtroom demeanor, serious, procedural, and unbending. Karoline approached the podium. "Your name?" the judge asked. "Karoline Leavitt," she said. He glanced down at the file. "Are you a licensed attorney?" "No, Your Honor." "Then, on what grounds are you here today?" Karoline responded with clarity. "I am a named representative of the Constitutional Advocacy Group bringing this case. I request to present our argument in person, in accordance with the court's rules for self-representation." The judge paused. Then he said the words that would set the internet on fire hours later. "You're not qualified to be here." The silence that followed was heavy. Reporters leaned in. The opposing attorneys exchanged glances. Some in the courtroom stifled laughter. To them, the hearing was over before it began. Karoline, however, didn't move. She didn't react. She didn't flinch. She spoke. "Your Honor," she said, measured and respectful, "I understand I do not have formal credentials. But this court has the discretion to hear arguments from parties representing themselves in matters of constitutional concern. I am here, not because I hold a title, but because I believe this case deserves to be heard." The judge said nothing at first. He simply studied her. Then he nodded slowly. "Proceed." The room shifted. The mood changed. She had been given the floor. And the people who thought she was just another media figure pretending to be something more were about to witness something entirely different. What followed was not just a legal argument. It was a turning point. Karoline Leavitt, a woman dismissed as unqualified, would soon deliver one of the most compelling legal presentations that Courtroom had seen in years. The courtroom was silent, as everyone waited. The hearing had ended 2 weeks ago, but the tension hadn't faded. If anything, it had only grown. Political commentators debated it on cable news. Legal podcasts dissected her arguments, line by line. Social media exploded with reactions ranging from admiration to outrage. And now, finally, the verdict was in. Inside a packed federal courtroom, the judge re-entered. He looked more solemn than usual, his eyes scanning the room before resting on Karoline Leavitt. She sat calmly in the front row, her hands folded, eyes steady. She wasn't nervous. She was ready for whatever came next. The judge cleared his throat, and the room fell still. This court has carefully reviewed the arguments presented, including those made by petitioner Karoline Leavitt, acting pro se. While she is not a licensed attorney, her statements were well-informed, respectfully delivered, and rooted in both fact and constitutional precedent. A pause. After consideration, this court finds the challenged policy in violation of the First Amendment to the United States Constitution. The words hit like a thunderclap. Karoline had won. But it wasn't just her win. It was a victory for the principle she had stood up for, that ordinary citizens, armed with knowledge, preparation, and conviction, could still challenge the most powerful institutions in the country. The courtroom broke into quiet gasps, some of disbelief, others of amazement. Even those who had come skeptical, some reporters, a few spectators, maybe even the judge himself, were now witnessing something that didn't happen every day in American law. An outsider had walked into the system and beat it at its own game. Karoline stood, nodded respectfully to the judge, and turned to leave, not with celebration, but with the calm of someone who had known all along that the truth was on her side. Outside, the world had already erupted. Reporters crowded the courthouse steps. Cameras flashed. Questions flew in every direction. Karoline, how does it feel to win? What do you say to those who called you unqualified? Will you go to law school now? Do you see yourself running for office again? She stopped only once to answer. I didn't do this to win anything for myself. I did it because the Constitution matters. If regular people don't stand up for it, who will? That quote alone made the front page of 3 major newspapers the next morning. National reaction, a firestorm. The ruling sparked a tidal wave across political and legal circles. Conservatives hailed it as a David versus Goliath victory. Talk show hosts called Karoline a constitutional warrior. Even centrists who didn't agree with her politics admitted she had done something rare, something powerful. Legal experts were divided. Some said the ruling could set a precedent for more citizen-led challenges to government power. Others worried it would open the door to chaos in the courts. But one thing was undeniable. Karoline Leavitt had shaken the system. Law schools, once silent on her presence, now used her courtroom performance as a case study. Was it possible that the gatekeepers of the legal system had become too rigid, too exclusionary? Could someone without a JD still contribute meaningfully to legal debate? Karoline didn't wait for those answers. She got back to work. A spark becomes a movement. Within weeks, she was invited to speak at universities, town halls, and legal conferences, not as a politician, but as a citizen advocate. She launched an online platform to teach young Americans about constitutional rights and how to participate in government, not just through voting, but through action. Thousands signed up within days. Parents, students, veterans, and young professionals reached out, inspired not just by what she said, but by what she did. She didn't just tell people they had power, she showed them how to use it. Suddenly, Karoline Leavitt wasn't just a political commentator or campaign veteran. She had become a symbol of what it meant to take ownership of the law, not to manipulate it, but to protect it. And across the country, that message caught fire. People began filing public records requests, attending local council meetings, reading the Constitution again, not because they were forced to, but because Karoline had reminded them that the law wasn't reserved for elites. It belonged to everyone. The establishment responds. Of course, not everyone was thrilled. Some legal scholars downplayed the case, calling it a fluke. Career politicians accused her of grandstanding. One prominent law journal published an op-ed titled, "The Danger of Making Heroes Out of Amateurs." But those critiques didn't stick.
Why?
Because the ruling still stood. The court's words were clear, and no amount of dismissive commentary could erase what had happened in that room. A young woman, deemed unqualified, had presented a constitutional case so strong, so logically sound, that even the federal bench had to acknowledge it. And in doing so, she changed the rules. The road ahead. Karoline Leavitt didn't announce a new campaign after the ruling. She didn't sign a book deal or join a major news network. Instead, she doubled down on her mission to awaken the next generation of citizens and restore their connection to the Constitution. And she did it the same way she had won in court, not with noise, but with clarity. She began hosting workshops, creating simple guides to court procedure, teaching people how to file public interest lawsuits, and encouraging civic action. In every speech, she repeated one line: "You don't need permission to be heard. You just need to be prepared." It became her motto, her message, and maybe even her legacy. Because what started as a courtroom showdown had turned into something far bigger, a reminder that the American experiment doesn't survive on institutions alone. It survives on individuals who care enough to protect it. And on that day, in that courtroom, Karoline Leavitt proved she was one of them. End of story. The courtroom was still buzzing. What Karoline Leavitt had just done wasn't supposed to happen. She wasn't supposed to speak. She wasn't supposed to be taken seriously. And she definitely wasn't supposed to outperform the legal elite. But she had. And now, the professionals on the other side of the aisle were scrambling. The lead attorney for the opposition, a man with 20 years of courtroom experience and a reputation for steamrolling his opponents, stood up with a different energy than he had just an hour ago. He was no longer smirking, no longer relaxed.
He was on defense.
"Your Honor," he began, "with respect to the petitioner's presentation, I feel it's necessary to clarify a few points for the record." This was a strategic move. The lawyer wasn't going to attack Karoline directly. That would make him look petty. Instead, he tried to dismantle her argument piece by piece, subtly implying that while she had made a strong presentation, it was ultimately incomplete. He pointed to procedural technicalities. He brought up obscure interpretations of case law. He cited district court rulings that contradicted her position. His voice was firm, his language dense, classic legal tactics designed to overwhelm anyone without formal training. But Karoline wasn't overwhelmed. She listened. She took notes. And most importantly, she understood. When the judge asked her if she wished to respond, she stood again, this time with even more confidence. "Your Honor," she said, "I appreciate counsel's clarification, but I'd like to offer a few counterpoints." Then she went line by line, calmly, clearly, and without flinching. On the procedural issues. Those rules apply to class action suits. This is a direct constitutional challenge brought by individual petitioners. Different rules apply. On the obscure case law, the ruling cited by opposing counsel was later limited in scope by a separate decision in the Ninth Circuit. It's not binding here. And on the constitutional principles, the government cannot restrict speech simply because it finds it inconvenient or politically undesirable. That's not just a legal interpretation. That's the foundation of the First Amendment. The judge nodded. The gallery stirred again. Once more, Karoline wasn't just reacting. She was leading. She wasn't playing defense. She was pushing the case forward, on legal grounds, not emotional ones. And the opposing team knew it. They had expected an easy win. Instead, they were now locked in a real legal battle against someone they had assumed was just a political figure trying to make noise. What they underestimated, what almost everyone had underestimated, was how deeply Karoline had studied this case. Not just the arguments, but the legal environment around it. She wasn't parroting talking points. She had anticipated their moves, studied their strategies, and prepared her rebuttals long before the court session had even started. The lead attorney tried again. This time, he shifted focus to jurisdiction. "Your Honor, we question whether this court is the proper venue for such a challenge," he argued. "There's a threshold question here about whether this matter even belongs in federal court." A subtle maneuver, If they couldn't beat the argument, maybe they could kill it on a technicality. But Karoline had that covered too. She stepped forward again. With respect, Your Honor, this case involves a direct challenge to federal administrative policy. Jurisdiction is appropriate under Title 28, Section 1331. The facts of this case establish standing, injury, and causation, all necessary under Lujan v. Defenders of Wildlife to proceed. Now, even the judge looked surprised. She wasn't just matching the professionals. She was citing Supreme Court precedent, accurately, fluently, and with context. And it wasn't just legal observers who noticed. Back in the gallery, journalists who had come expecting a political stunt were now realizing they might be witnessing history. Phones buzzed. Headlines were being drafted in real time. Tweets were flying out. Karoline Leavitt dismantling career attorneys in federal court. This is wild. She's not a lawyer, but she just cited Lujan better than most law professors I've heard. This courtroom just turned into a constitutional masterclass, and Karoline is teaching it. Inside, the tension was building. The back and forth between Karoline and the opposing team went on for another hour. Every time they tried to corner her, she stepped out with a precise counter. She wasn't argumentative. She wasn't aggressive. She was just prepared, more than anyone had expected, possibly more than anyone in the room. Even the judge, who had begun the day questioning her right to speak, was now giving her the same space, attention, and respect as any seasoned attorney. By the end of the session, it was clear that Karoline Leavitt had done more than survive the courtroom. She had dominated the legal battlefield. And yet, she never once made it about herself. She never raised her voice. Never grandstand. She let the law speak for itself. Because for Karoline, this wasn't about ego or headlines. It was about protecting a principle. And she understood that the most powerful argument isn't shouted, it's shown, calmly and confidently, through knowledge and conviction. As the hearing adjourned, the judge issued a statement that left the room speechless. This court recognizes the clarity, relevance, and thoroughness of the petitioner's presentation. Her arguments will be taken into full consideration as the court prepares to rule on this matter. A statement like that, about someone without legal credentials, was almost unheard of. But that's exactly what Karoline Leavitt had done, the unheard of. She walked into a courtroom where she didn't belong, stood toe-to-toe with trained professionals, and held her ground using nothing but her preparation, her voice, and her faith in the Constitution. And now, the only question remaining was this. Would it be enough to win? The courtroom had been quiet for too long. After the judge told Karoline Leavitt she wasn't qualified to speak, everyone expected her to walk away, maybe with a polite nod, maybe with a look of embarrassment. But instead, she did something no one was ready for. She stayed calm. She stood her ground. And then, with a measured breath, she spoke. Your Honor, I fully respect the rules of this court. I also recognize I do not have a law degree. But I am a named petitioner in this case, and I believe I have both the legal right and civic duty to speak on this matter. The argument I've prepared is rooted in constitutional text, legal precedent, and fundamental rights protected by the First Amendment. The judge didn't respond right away. He simply studied her. It wasn't defiance in her voice. It wasn't arrogance. It was something else, something the judge, the opposing attorneys, and even the spectators hadn't expected to hear. Competence. Real, sharp, unshakable competence. The silence in the courtroom deepened. What had started as a moment of awkward tension was turning into something much more interesting. She continued. I've prepared a motion to speak as a pro-se petitioner under Rule 17. I understand that the opposing counsel has formal training and experience beyond mine. But I believe that this issue, the constitutional issue at the heart of this case, belongs to the people. And I am one of those people. The judge raised his eyebrows slightly. It wasn't approval, but it wasn't dismissal either. Across the aisle, the opposing attorney whispered something to his colleague. They were starting to realize what everyone else in the room was beginning to feel. Karoline Leavitt wasn't just bluffing her way through this. She was ready. The judge glanced back at the file, then at Karoline.
Proceed, he said at last.
That one word changed everything. Karoline adjusted the binder in front of her and began her presentation. Her voice was steady, her tone clear. She started with the facts, brief, crisp, and focused. She outlined the government policy in question, detailed how it had been enforced, and explained why it violated the constitutional rights of citizens. She spoke not like a lawyer, but like a teacher, guiding the room through legal precedent, from Marbury versus Madison to Brandenburg versus Ohio, weaving together a narrative that was not only legally sound, but deeply compelling. No theatrics. No dramatics. Just clarity. As she spoke, something remarkable happened. The courtroom leaned in. Even the judge, who had opened the session with a pointed dismissal, began nodding as she laid out her framework. She cited case law accurately. She quoted constitutional text with precision. She responded to interruptions from the opposing counsel without hesitation. At one point, when the other side tried to discredit one of her claims by citing a Federal Circuit Court ruling, Karoline calmly responded. That ruling was overturned on appeal in 2019, Your Honor. The appellate court ruled that the enforcement mechanism in question constituted a form of compelled speech, which is exactly what we are arguing in this case. There was no smugness in her voice. Just facts. Just law. And now, everyone in that courtroom was seeing it. Karoline Leavitt wasn't just giving a good performance. She was winning the argument. The judge leaned forward in his chair. The opposing attorney stopped smiling. And the journalists in the back row who had come expecting a quick embarrassment were now furiously scribbling notes. This wasn't just unusual. It was unprecedented. Here was a 25-year-old woman with no formal legal credentials, holding her own and even outperforming professional litigators in a federal courtroom. She continued for nearly 45 minutes without pause. Her notes were tight, her transitions smooth, her delivery exact. She anticipated counterpoints, addressed concerns before they were raised, and made sure the heart of the case stayed front and center. And as the minutes passed, something shifted, not just in the judge, but in the room. She wasn't an outsider anymore. She was the center of the legal debate. When she finished, she closed her binder quietly and stepped back. For a moment, the judge said nothing. Then he spoke. Ms. Leavitt, your argument is well prepared. You've cited relevant precedent. Your presentation was orderly and direct. The court acknowledges your standing as a petitioner and will allow the record to reflect your statements as part of the official proceeding. The courtroom murmured. People glanced at one another in disbelief. Karoline nodded once, thanked the court, and returned to her seat. The silence wasn't out of shock anymore. It was out of respect. The woman they had all underestimated, the one the judge had called unqualified just an hour earlier, had just delivered one of the strongest constitutional arguments that courtroom had seen in years. Outside, the news was already spreading. Reporters rushed to file their first stories. Headlines were being written before the hearing had even adjourned. Inside, one thing was clear. This was no longer just a procedural hearing. It was a moment, a turning point, and Karoline Leavitt had just changed the entire tone of the case, possibly even the outcome. She wasn't there for show. She was there to fight. And the courtroom, once skeptical and dismissive, had now become her audience. The next move was up to the opposition. But after what they'd just seen, they would have to work a lot harder to win. To understand why Karoline Leavitt's presence in that courtroom was so shocking and so powerful, you have to know who she is and where she came from. She wasn't born into power. She wasn't raised in Washington, D.C., or in the elite circles of law and politics. Karoline was raised in New Hampshire, in a working-class family where values like hard work, personal responsibility, and patriotism weren't just talked about, they were lived. From a young age, Karoline was drawn to American history and politics. While other kids her age were watching cartoons, she was listening to debates, reading about the Constitution, and asking questions most adults couldn't answer. Her interest wasn't academic, it was personal. She believed deeply in the idea that the United States was a nation built on principles worth defending. As she got older, her voice began to stand out. Karoline graduated from St. Anselm College with a degree in politics and communication. Her passion wasn't limited to books or theory. She wanted to be where the action was. Shortly after college, she made her way to Washington, D.C., where she quickly found herself in rooms that most people twice her age never entered. She worked as an assistant press secretary in the Trump White House and later as the communications director for a prominent Republican congressman. Her ability to articulate conservative values with clarity and fire made her a rising star in political media. She appeared on cable news, gave speeches at rallies, and was invited to speak at major political events across the country. But with visibility came criticism. Mainstream media outlets called her too young, too extreme, or too inexperienced. Detractors often dismissed her as just another social media figure trying to make headlines. But those who worked with her behind the scenes knew better. Karoline was disciplined, strategic, and focused. She spent hours poring over legislative texts, writing opinion pieces, and studying American legal history, not because she had to, but because she believed that understanding the structure of government was the key to defending freedom. While she never went to law school, she developed a deep understanding of constitutional law through mentorship, self-study, and first-hand experience working on policy. She wasn't just repeating political talking points. She was dissecting legal frameworks, tracing the roots of American jurisprudence, and challenging her peers to go deeper. And yet, despite her rising profile, Karoline never claimed to be a lawyer. She didn't pretend to be something she wasn't. She believed in staying in her lane, until the moment came when that lane no longer existed. When the constitutional advocacy group she supported lost their legal team just 48 hours before a crucial hearing, Karoline didn't see it as a moment to promote herself. She saw a responsibility. "I knew what was at stake," she later said in an interview. "I couldn't let the case die just because the attorneys couldn't show up. Someone had to stand up. So I did." It wasn't ego. It wasn't ambition. It was conviction. The case she stepped into dealt with a core constitutional question: whether a specific federal policy had infringed on the free speech rights of American citizens. It wasn't about politics. It was about principle. And Karoline had spent years preparing for a fight like this, just not in the way most people would expect. Supporters praised her courage. Critics called her reckless. The legal world debated whether her appearance in court should even be allowed. But Karoline had one thing on her side that no credential could replace: credibility. She wasn't pretending to know the law, she knew it. And, more importantly, she knew how to defend it. Even those who didn't agree with her politics couldn't deny her preparation. She had researched the case files, memorized Supreme Court precedents, studied the court's procedural rules, and anticipated the opposition's arguments. She wasn't just walking into court to make a statement. She was walking in to make a case. And that's exactly what made her dangerous to the establishment. In a system where gatekeepers often use titles and degrees to keep outsiders out, Karoline represented something disruptive. She was part of a growing generation of Americans who believed that knowledge, not credentials, should determine who gets to speak. Of course, the legal world didn't see it that way. The moment she stood before the judge, it was clear that she wasn't welcome. She was underestimated, expected to flounder, to fail, or to flee when challenged. But Karoline didn't flinch. Because behind the media soundbites, the political controversies, and the headlines, she had spent years doing something few realized: preparing. Not for attention. Not for a moment in the spotlight. But for moments exactly like this, when the system seemed stacked against the people it was designed to serve. And now, with a judge questioning her right to be in the courtroom, Karoline Leavitt stood not just as a political figure, but as a citizen fighting to be heard. The courtroom didn't know it yet, but they weren't just about to hear an argument. They were about to witness a battle of ideas. And the woman they called Unqualified was about to show them just how qualified conviction, clarity, and courage could be.